Good morning. Today's topic is administration of justice. My name is Umesh Rao. In this class, we are discussing what is the administration of justice. What is justice and what is the importance of justice? What is the necessity of the administration of justice? Origin and growth of administration of justice. Advantages of legal system, disadvantages of legal system, public justice, private justice, that means kinds of justice, and kinds of justice, civil justice, criminal justice, functions of the law. Now, before going to study what is administration of justice, we should know the importance of justice. What is the importance of justice? How to judge a nation's rank in political civilization? Test of excellency of a government is judged by the efficiency of its judicial system. George Washington, he said, administration of justice is the finest pillar of the government, and law exists to bind together the community. Salmon and Ross Pound have emphasized the importance of justice in their definition of law. Salmon defined law is body of principles recognized and applied by the state in the administration of justice. Another author, Blackstone, he said, justice is not derived from the king as his free gift, but king is the steward of the public to dispense it to whom it is due. He is not the spring, but he is the reservoir from it might equity are conducted by thousands of channels. Now, what is the administration of justice? First, we have to see what is the function of the state. Function of the state is only two things: war and administration of justice. If the state is not capable of performing either of these two functions, it cannot be called a state. According to Salmon, administration of justice implies maintenance of right within a political community by means of physical force of state. Salmon gave importance to physical force. Because of the force, people are afraid of law. People are following law. That is his notion. But his definition is criticized on the following grounds. What is the physical force? Physical force means it is a punishment. It is the force of the state alone that secures the obedience of law. The number of other factors, such as social sanctions, habit, convenience, which help the obedience of law. In a modern state, physical force is not important. Salmon definition is criticized. He gave importance to only force. His critics said that it is not the force of the state alone that secures the obedience of law. There are a number of other factors that serve the obedience of law, such as social sanctions, habit of the people, convenience, which help the observance of law. In civilized society, obedience of law becomes a matter of habit. In very rare cases, force of the state is used to secure the justice. What is the necessity of the administration of justice? Jeremy Tyler explains man's nature, how man behaves. He says herd of wolves are better than so many men. Wolves are quieter than men. Hence, to control men, one power is necessary. It is the administration of justice. Another thinker, Hobbes, says that without a common power to keep them all, it is very difficult to control society. Without administration of justice, it is not possible for individuals in a society to grow. Administration of justice, if justice is unchecked, life of the people will become solitary, nasty, poor, brutish, and short. Salmon explains man's nature. He said, man is by nature, he is a fighting animal. Each man is moved by his own interests and passions. How to control men? Alternative is one, power over men. It is the force. Without force or without power, civilization is unattainable. So he said that important power is the force, but another important power is that is force of public opinion. Public opinion gives valuable support for a system of law. However, public opinion is not substitute for legal sanctions or punishment, because man cares not for the opinion of the public, man cares more for the opinion of his friends and immediate associates than the opinion of the world. Thief always give importance to the advice of another thief. The censure of 1 lakh persons, it doesn't care for him. It is outweighed by the approval of 10 persons who belong to his profession. The honor of the thief finds support from his fields or his friends belonging to their profession. So, force is necessary to control minority and prevent them from gaining unfair advantage over the law abiding majority in a state. To conclude, administration of justice with the sanction of the public force of the state is unavoidable. The origin and growth of administration of justice. Administration justice, it is like the origin of growth of man. Man wants to live in society. While living in society, he experienced conflict of interests. These conflict of interests created the necessity for providing administration of justice. We can study the growth of administration of justice under 3 stages. First stage of development of man. Here, every individual had to help himself. He has to punish the wrongdoer. Man avenged himself upon his enemies by his own hand. Sometimes he was supported by his friends and family members. At this stage, every man carried his life in his hand. Every man, he may be liable to be attacked at any time. He has to resist his opponent. Every man was the judge of his own cause. There is no guarantee that crime will be punished in proportion to the gravity of the offense. Not on individuals, even the family members could be the victims of retaliations. Blood feuds are common. Then came payment of some money or compensation to the victims of the crime or relatives of the victims. In the case of murder, vengeance of retaliation could be purchased by paying blood money. Then comes second stage of administration of justice. Justice started with the rise of political states. However, states are not strong enough to regulate the crime and give punishment to criminals. Private vengeance and violent self-help continue to prevail. State regulated merely private vengeance and self-help. State is only monitoring. State prescribed some rules for the regulation of private vengeance. It is state enforced the concept of tooth for the tooth, eye for the eye, life for the life. But life should not be taken for eye or tooth. This is the second stage. Then comes the third stage. This stage became to state began to act as a judge to assess liability and impose penalty. State is no longer a regulator of private vengeance. State conducted public inquiry. Punishment started from state. Administration of civil justice helped the wronged, and it became substitute for violent self-help of olden days. Advantages of legal justice. Legal justice ensures uniformity and certainty in the administration of justice. Everybody knows what the law is, and there is no scope for arbitrary action. Judges have to give decisions according to the declared law of the country. As the law is certain, citizens can shape their conduct accordingly. There is impartiality in the administration of justice. Judges require to give their decisions according to the predetermined legal principles. Law is already laid down, and judges have to act accordingly. The wisdom of the law is wiser than any man's wisdom. Legal justice represents the collective wisdom of the community, and that is always be preferred to the wisdom of the individual. Disadvantages of the legal justice. Law is rigid. Law has already been laid down in precedents, and it is not possible to adjust it to the changing needs of the society. Society may change more rapidly than legal justice. It results in hardship and justice. In certain cases, it causes injustice to person. Judges attach more importance to the legal technicalities than they deserve. They give more importance to the form of justice than the substance. Now, public justice and private justice. What is public justice? Public justice, it is administered by the state through its own tribunals or its own courts. Public justice is relation between the courts one side, one side, and the individuals on the other hand. Force can be used in the case of public justice. Private justice, it is the justice between the individuals. It is the relation between the individual. There is no place for force in the private justice. Private persons are not allowed to take the law into their hands even if a wrong has been done to them. They must refrain from helping themselves. Justice and its kinds. Criminal justice. Justice of two kinds. One, criminal justice and civil justice. Criminal justice. There is a difference between crimes and civil wrong. Crimes are public wrongs. It is a breach of public rights and duties. Civil wrongs are private wrongs. These wrongs, crimes or public wrongs, it affects the whole community. Civil wrongs are private wrongs. They are civil wrongs because it is infringement of private rights or civil rights. It is belonging to the individuals. It is a state. Crime is harmful to society in general. For example, murder, it affects primarily the particular individuals. But it is not the matter between the murderer and the family of the murdered. Person who committed the murder is proceeded against by the state, and they are punished and convicted because murder is an offense against the state. But in civil law, infringes only the rights of the individuals and not the society. Victim can sue for compensation in the courts. Civil justice is administered according to the one set of forms and one set of courts. Criminal justice is administered according to another set of forms or another type of courts. Civil proceedings result in judgment for damages, penalty, injunction, specific performance, delivery of possession of land, decree of divorce, order of writs like mandamus, prohibition, certiorari, habeas corpus. But criminal proceedings result in a number of punishments ranging from fine to hanging. Object of the civil proceedings is to enforce rights. Object of the criminal proceedings is to punish the wrongdoer, punish the wrong. But punishment sometimes juvenile, juvenile offender or minors, they may be just warned and not punished. Crimes are more harmful in their consequence than the civil wrongs. Crimes injure the public at large. Civil wrongs injures only private individual. In crime, state constitutes a party for the proceeding in the crime, but in civil proceedings, private individuals are the parties. Civil wrongs, they are private wrongs. They are infringement of private rights and civil rights belonging to individual. Civil wrongs are deemed to infringe only the rights of the individual wronged and not the society. The object of the civil justice is to provide compensation to the aggrieved party or sufferer by wrongdoer. Civil justice is administered according to one set of forms and one set of codes. So, civil proceedings result in infringement of damages or in judgment of the payment of that or injunction, decree or specific restitution of delivery or possession of decree or civil cases. There are no punishment. In civil cases, it is the duty of the party to place their case as they think. The burden of doubt does not arise in civil cases. Proceedings may be withdrawn by the parties with their own consent. The rule of evidence may be relaxed. Code, civil courts administer civil justice. Now, function of the law. What is the function of the law? Regulate the human conduct and serve general standards. Purpose of the law is to give justice, equal treatment to all. Distributive justice and corrective justice, two types of justice are there. Law maintains uniformity and flexibility. Now, what is the functions of the court? Primary functions and secondary functions. Primary functions, civil justice and criminal justice. Secondary functions, court has to take action against the state when state violates fundamental rights. Second, declaration of rights of the individuals. Third, management and distribution of property. Fourth, title and rights. These are all the secondary functions. Thank you.